matter of P and in the matter of Lorraine Gallagher.
And before we begin, I have two announcements to make. One of which is the most sincere congratulations, Sir James, on your recent knighthood. I'm sure every member of the court would wish to give you those congratulations and say how richly deserved it is.
Very grateful.
Whether it makes your submissions any more persuasive, we will wait and see. The second announcement, of course, is that there is an anonymity order in this case. And just to remind everybody present that the court has ordered that no one shall publish or reveal the name or address of the respondents P, G and W, or of the appellant P, who are the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of them or of any members of their family in connection with these proceedings, just to remind everybody. And that includes every sort of communication. Thank you. Now you can get on with it, Sir James.
Grateful. My lady, I understand there's going to be a minute's silence at midday.
At midday, yes, it will be announced.
Be announced. I'm very grateful. My lady, my lords, you have the cast list. We've rejigged some of the timetable. I think my replies got 15 minutes shorter, and Mr. Offer has sacrificed some part of his time. But I hope you have a revised, agreed timetable that the parties have agreed, if that's acceptable to the court. There's a little bit of flexibility this afternoon, perhaps, because I may drift a little bit into Mr. Cole's time later on today, and he's very gratefully or very kindly agreed that I can do that if I need to, but we'll see how we get on that.
We did think the timetable was a tad generous.
My lady, yes, well,
given that the issues overlap between the cases to a very considerable extent and only the facts are slightly different.
well, my lady,
So if anybody can trim any time off, it will be to everybody's advantage, including ours.
bear that in mind. My lady, my submissions, I'm going to start with the nature of the scheme and the nature of the changes since this set of issues was last before the court, which wasn't terribly long ago in the T case. Then I'm going to make some submissions about the approach in principle as we submit it to be, particularly focusing on in accordance with law, but also picking up necessity. Then I'm going to come to the specific features which are challenged, as it were, of the new regime, and then some very brief submissions on the cross appeal, which relates to remedy at the end. So if I can start with the nature of the scheme, and I start with the position as it was at the time of T and before legislative amendment. And I'm going to take that, I hope this is a convenient and quick way of doing it, I'm going to take that from the judgment of Lord Reid in the T case, which you find behind tab 21 of bundle 3 of the authorities, and I'm going to go to paragraph 67, page 883 on the MS numbering. So para 67 of Lord Reid in the T case. It's also, for your note, and if you want it, set out in a little more detail in our case between paras 6 and 30. But the basic structure starts with the common law position and in effect, the default position that Lord Reid sets out at paragraphs 67 and 68. In essence, the position at common law was that a prospective employee had to answer fully and had to disclose convictions, in a nutshell. Then came the 1974 Act, the Rehabilitation of Offenders Act. If you want it in the raw, it's behind tab 3 of Authorities Bundle 1, MS 231, but perhaps for present purposes, all we need are the relevant provisions set out in the judgment of Lord Reid at 69 and following. The Act is dealt with in Lord Wilson's speech, if you prefer it there, between paras 6 and 7. But the basic common law position was altered by the 1974 Act. And the position under that Act was that once someone had become rehabilitated in respect of a conviction, it was as if it never happened. So the conviction becomes, in the language, spent. That's the effect of subsection 1 of section 4, quoted by Lord Reid at paragraph 70. And the alteration of the common law position is then dealt with in 4.2, quoted in para 72, and 4.3, quoted in para 73. And again, in summary, and brief summary, the provisions there set out meant that the person could treat, the prospective application for employment, for example, could treat questions about convictions as if they weren't asking about spent convictions. See the final sentence of para 72 for that summary in the judgment of Lord Reid. But that position, that altered position, was itself subject to exceptions, just to make the scheme complicated enough. Section 4.4 deals with those and empowers the Secretary of State to make orders modifying the circumstances in which 4.2 and 4.3 apply. And you see subsection 4 in para 71 of Lord Reid's judgment. Cautions were not originally dealt with under the 1974 Act, but as we see from para 76 in Lord Reid's judgment, there was provision regulating cautions under the scheme of that Act from December 2008, and the same structure as in relation to spent convictions, but cautions became spent, as we see between B and C on MS 886 within para 76, they became spent when given. There was then the Rehabilitation of Offenders Act 1974 Exceptions Order 1975 that Lord Reid deals with at paragraphs 77 and following. It was made, so far as relevant, under section 4 sub 4 of the 1974 Act, as we've seen, and its basic effect in Article 3 was to bring back obligations to answer truthfully or to provide truthful information about convictions or cautions. And it does that, if one wants the convoluted statutory process or legislative process, by excluding the application of sections 4, 2 and 3 to questions asked in specified circumstances. One sees that effect dealt with at 78 and 79 in Lord Reid's judgment. And those specified circumstances included various professions, working with children, working with vulnerable adults, and so on. And the list, if you want the examples, are perhaps rather more fully summarised. If you just flick back in the bundle to page 863 on the MS numbering and go to para 7 in Lord Wilson's judgment, you will see in the second half of that he lists 6 examples of the 13, and that gives you a flavour of the range of circumstances now covered. What paragraph was that? Paragraph 7, my lord, I'm sorry, page 863. You see the second half of those, he gives examples, 6 examples of the sorts of employment where you have to answer truthfully, in effect. So that's the suite of legislation, as it were, that governs the position vis-à-vis employer and employee and alters the various requirements that the common law used to impose to answer all questions about convictions, truthfully, however old they were, providing for spent convictions and for the legal consequences of that. The next part of the scheme is is in effect the reaction of central government providing answers to the question, have you got a conviction or a caution or not? And that scheme is set out in the Police Act. If you go back to Lord Reid's judgment at 887, it is to that Act that he turns between 81 and 87. So he there sets out the statutory scheme, as it was then, for disclosure of criminal records and other information held by the police, where required in order to assess suitability for the particular types of position that we saw examples of in Lord Wilson's judgment at para 7. So as Lord Reid explains in paragraph 86, this part of the legislative scheme goes beyond, as he puts it, innovating on the common law. But its practical effect is to enable employers in such positions to have access to the central records and information, or the police records and information, when considering applications, as Lord Reid points out in paragraph 81. The precise mechanics as to how that occurs are dealt with in para 82. So the individual applicant applies to the Disclosure and Barring Service, the DBS, for a certificate. He initiates the process because he wants the position, in essence. And the certificate is then, depending on the sensitivity of the post, either a criminal record certificate, a so-called CRC, or an enhanced criminal record certificate, an ECRC, the difference between the two in a nutshell being that the ECRC includes soft intelligence that police might hold rather than conviction and caution information.
And a discretion.
And the discretion.
And calls for a judgment at the time of formation, doesn't it?
Yes, by the police as to whether or not to include, and I'll come back to that because obviously there's a debate around the significance of that. But my lord and my lady are right. But the application is accompanied, so that's the application by the applicant for the post, is accompanied by a statement from the employer or the regulatory body that a certificate is required for, as it's put, an exempted question. In other words, a question in relation to which section 4.2 of the 74 Act has been excluded by the order made under 4.4. So in other words, in effect, saying we need this information for the purpose of considering suitability for one of the posts, examples of which were listed by Lord Wilson at paragraph 7.
That's the only information, as I understand it, that is supplied to the discloser, namely, what is the purpose for which it's required. There's no detailed description of the proposed employment.
There isn't. And so the material that comes back, as it were, applies across the range of posts. My lord is right. What is disclosed? Well, that's dealt with by Lord Reid at 83 and 84. And in summary, under 113A, which I'll go to in the amended form in a moment, but under 113A and subject to specific exception, it's any caution or conviction, or it was at the time, any caution or conviction, para 83. It had to be a recordable conviction, so there was that filter at that stage, but it was, other than that, it was any caution or conviction. And then the additional information is dealt with in paragraph 84 under 113B. So you've got local police information or intelligence which the chief of police reasonably believes is to be relevant and which ought, in his opinion, to be included in the certificate. And in undertaking that exercise, he has to have regard to guidance given by the Secretary of State. So perhaps for present purposes, the key features of that scheme under consideration by this court at that stage and until 29 May 2013 when the scheme was amended was that the CRCs and ECRCs contained all convictions and cautions even if spent. And the only differentiation within that statutory scheme was that it was only recorded offences held on the PNC which would be disclosed, and that includes all offences punishable by imprisonment and a specified schedule of additional offences, but not most minor matters. But that was the only differentiation or gradation in the scheme as it was then. So that was the scheme as it was at the time when this court considered the matter and the set of issues in T. Can I turn to the position as it is now? by the time that legislative change was made, coming into effect at the end of May 2013, as I've said, two things had happened. The first was that T had been decided, but only in the Court of Appeal. So the legislative change, which was subject of some comment by Lord Wilson in his judgment, occurred between Court of Appeal stage and Supreme Court stage. And as Lord Wilson pointed out, it would have been slightly piquant if the government had won the appeal in T in those circumstances. But nevertheless, for good or ill, that change was made in the light of the Court of Appeal judgment. And the Court of Appeal, as this court ultimately did, decided that the scheme as it had been, the legislative canvas, was painted with too broad a brush. And secondly, and before and in parallel with that litigation as it went up the courts, there was ongoing a process of careful and detailed consideration to the changes that might be made to the scheme to make it more nuanced, to design, if you will, appropriate filtering mechanisms. And that process is described in the evidence that you have in your bundles. Can I invite you to take up Appendix Part 2D? I don't know whether that's terribly readily to hand, but... Appendix Part 2D, it's MS 7385, is the first page of the first witness statement of Miss Alison Folds.
Sorry, can you give me that page again?
It's MS 7385. I don't know whether in the blue volumes you've got the MS numbering.
No.
No, well, I better give you both, and that's 1262. But she there describes the process that had been gone through. And you see from that description, if you go to paragraph 11 within that statement, MS 7387 or hard copy 1264, you'll see that as early as September 2009, the Secretary of State appointed Sarita Mason as the Independent Advisor for Criminality Information Management and had instructed her to conduct a review in this area. And the background had been an earlier piece of litigation that you see summarised at paragraph 11. She had reported in 2010, in March, first of all, and that report is in that bundle, and the first page of it is at 7403 or 1280. And so she produces in March of 2010 a report, and the essence of that report, perhaps one can take briefly from the executive summary at 7409 or 1286. You'll see she deals with a range of subjects, but so far as relevant under the executive summary on that page, if you have a look at the title halfway down that page, Disclosure of Police National Computer Records for Employment Vetting, and you see in particular Roman 5 and Roman 6 on that page. So in essence, her recommendation at that stage is that there needs to be a process of more sophisticated filtering, and there should be an expert panel set up to have a look at the issue, in a nutshell. So she then...
Well, she anticipates filtering rules, doesn't she?
She does. Specified business rules, which we'll then see how that developed. But she wanted also a number of interested parties to be brought together as an expert panel to advise on what they should be. And she then reports as para 16 of folds 1, if I can call it that without disrespect to her, para 16 of that on page 7389 and 1266 in the hard copy. That then leads to a report entitled A Common Sense Approach. I think that phrase was then used as a stick to beat me with in tea. But that report...
Feeling the bruises, Sir James. Still feeling the bruises.
Still feeling the bruises. The submission is going to be that there's only a twig left, but I'm sure that'll bruise too. That report is at... It starts at page 7453 or 1330 in the hard. But the relevant parts I think one can take from the body of the statement. So para 16 really pulls out the essence of it. Perhaps go to executive summary again. It may be helpful just to see, so you see the development. Sorry, if you go in the bundle to 7458 or 1335, and you'll see the task that she's set herself, as it were, in the third paragraph under executive summary. I have then considered the balance between public protection, civil liberties in terms of what is fair and proportionate to disclose, also reviewed the use of police information as part of enhanced criminal disclosures. And then you'll see the essence of the recommendation in the first of the recommendations on 7459 or 1336, recommendation number 5, as you see at the top of the page there. And then she makes the obvious point in the penultimate paragraph on that page that public protection system is a fundamental part of society's response and so on. Vital that protection remains in place, yet operates at a level that allows the greatest opportunity for the well-intentioned in society to work with those in need. And she reaches those conclusions and that summary of her conclusions after undertaking the work that is described on the next 2 pages in the foreword. She sets out, in essence, what she's done. And if you go in a little bit more detail, which is, I think, part of the bit that's quoted in her para 16, that lies underneath that recommendation 5, if you go in the bundle to 7479 or 1356 in the hard copy, you'll see a title in the left-hand column, Filtering of Old and Minor Convictions. And rather than my reading it out, and it's simply to give you a flavour, could I invite you just to read to yourselves from just under that title, Filtering of Old and Minor Convictions, through to the end of the next page, 7480 or 1357. The bit she's quoted is in the left-hand column on page 1357 or 7480. Perhaps the final one to read is that box at the very top of the left-hand column on 1358 or 7481. But you see at least the nature of her, in slightly more detail, the nature of the thinking that underlies recommendation 5 in those pages. And the filtering then continued, or the consideration of the filters then continued with the independent advisory panel which she headed. And it led ultimately to to 2 reports in December 2011. The longer one, I'm not going to really trouble you with because it dealt with quite a lot of other issues that don't exactly match the issues that we're dealing with. But The bit I did want to take you to in the December report is in the 19th of December report at 7620 in the electronic version and 1497 in the hard. You see the date from 1502 in the hard, 7625, December 2011. And just going over to the next couple of pages, you see the terms of reference on 1503 or 7626, and the membership of the panel on 7627 or 1504, including Mr. Justice Ryder, as he then was. And you see the essential recommendations. And they are the recommendations, I should emphasise, of Miss Mason, as one sees from the final paragraph on page 7625 or 1502, because there was a variety of views, perhaps unsurprisingly, amongst the independent panel as to how the thing should be set up. But if I could just invite you again, without reading it out, unless my lady will want me to, just to sideline the three levels of basic check that she sets out on 1497 or 7620. That's really describing the CRC and ECRC systems. And then the overarching principles, which she then seeks to identify, are set out on 7621 or 1498 in the hard, in those bullets. See in particular the third one. And perhaps the sixth one. Those are the overarching principles, but it is recognised, perhaps unsurprisingly or inevitably, that there's a lack, as she puts it in the second line of the final full paragraph on that page, 1498 or 7621, there's a lack of evidence-based research, and where that leads her is to consider that there should initially, as she puts it, be a cautious approach to implementation of any proposal for filtering, opportunity to consider things in the future. And then, in giving effect to that approach, you will see that that led, in essence, or that was the starting point for the two conviction rule, as one sees at the bottom of that page. A threshold pertaining to the number of convictions, cautions, warnings and reprimands as defined as minor should be applied. In the first instance, this should be set at 1, allowing individuals to be given a second chance and so on. And then she turns her mind to the definition of minor convictions and cautions. And there was, in essence, it looks as though there was quite a lot of disagreement about precisely where that line should be drawn, perhaps unsurprisingly.
If she, I mean, this is just one view, if she was thinking in terms of a second chance and underlying the two conviction rule, does it work like that? Or is it two convictions on the same occasion count? 2 children, 2 seatbelts, for example.
It's 2 convictions.
It is, isn't it?
It is.
So it isn't actually a second chance.
Well, it is or it isn't, depending upon how you look at it. It's,
all right.
It's blunter, I accept.
Yeah, okay.
What you don't have to do is to say, are these, as it were, offences within the same group committed on the same occasion, so we can discount them. It doesn't have the exception that my lord is driving at.
It's not conviction on 2 occasions, it's conviction of 2 offences.
It is.
Okay.
It is. And then you see the business rules that she suggests, in particular the 4 numbered ones at the bottom of 1499 and the hard 7622 in the electronic. And they perhaps need no introduction. And then she turns her mind to alternative approaches. And there was a variety of potential alternative approaches, as one sees. At the bottom of page 1500 in the hard, 7623 in the electronic. She's obviously concerned, as one sees from the sentence that straddles 1500 or 7623 in the next page, about the fact that the system currently operates and would continue to operate, in effect, as an automated system. But she considers the alternatives, for example, linking seriousness to penalties, and there are issues in this case about disposal, whether disposal will be a better or finer-tuned yardstick. She considers that. And then she considers, in essence, a system of individualized consideration with the courts deciding on disclosability. So you see halfway down 1501 or 7624. And a variant on that with the police deciding.
Police have, I mean, the record of conviction simply says, for example, theft. It doesn't, I mean, does one even know the count of the indictments on which?
I don't think you would on the central computer. I think you just get the offence. And you wouldn't get mitigation, you wouldn't get the counts on the indictment, you wouldn't get the...
know whether it was from a shop or from
you wouldn't.
pocket or...
I'll be correct if I'm wrong, my understanding is you wouldn't. And of
That's
course,
that's the point she makes on,
yes.
on 500, isn't it?
Right. There are, yeah. Anyway, the one thing I respectfully submit that is immediately apparent, even from this initial consideration of how a more nuanced scheme should work, is that there are a series of pretty complex judgmental issues surrounding the setup or design of the scheme. There are a whole variety of different layers or elements feeding into the decision in question, as is immediately apparent from that report. And there aren't just design issues, there are practical issues that feed into the design. If you go back to her statement 1269 in the hard, 7392 in the electronic, you will see that she's summarised a whole series of practical issues that people had to confront when they were seeking to redesign this sort of disclosure regime. Particularly paragraph 26, drawing on a statement by Mr. Woodcock, but perhaps the essence of it is adequately summarised in her paragraph 26.
We have Mr. Woodcock's statement.
I don't think we've got... Oh, yes, we have. I'm sorry, we have. We've got it in the bundle, if you want it in all its detail, at 1505 in the hard... or 7628. That's in Appendix 2E, so it's in the next volume, but if you want it, it's there. But so how each element is designed also involves judgment. I mean, take ABH as an example. I have to come back to it. Should it be in or not is the approach that says particular care or precaution on offences of violence, given that you're dealing with children and vulnerable adults, an acceptable one. There's a range of views about where the line of seriousness is or is not to be drawn. The same applies to disposals. Should the scheme be based on disposals? To some, and if so, to what extent? And if you do have regard to disposal, how fine a gradation do you introduce into the scheme? And there is obviously something of a trade-off between making the scheme effective and workable and supplying full information at all stages so that these judgments can be made on an individualised basis. I'm very grateful. My assumption on your question about different offence codes in the PNC and what information, can I simply refer you to 1584 in the hard copy? And I'll give you the electronic in one moment. So 1584, which I think is in Appendix 2E, and that sets out the offence codes. It's in the statement of Mr. Ray.
What's the electronic number, please?
It's 7707.
Uplifting is a separate code.
Yeah.
Yeah, and then you read paragraph 7 underneath that, if you would.
Could apply to anything from a bar of chocolate to a hi-fi system.
Yeah.
Yeah. Yes, perhaps you ought to read para 9 while you're there as well, over on 1585 or 7708. And still on the issues that surround the design of that scheme, and to some extent in the territory of my Lord's questions on that front, serious and legitimate questions it might be thought about making the scheme operable and efficient, given the scale and the numbers involved. And so far as scale and numbers are concerned, if you go back to Miss Foles's first statement in 2D, if you still have that open, 1264 in the hard, 7387 in the electronic, and go to paragraph 10, you see the sorts of numbers that are involved, at least in England and Wales. And perhaps rather than turning them up, if you write next door to that paragraph, see also paras 27, with a little more breakdown, and 36, just giving you those evidential references for scale of system, and see also in the core volume for P, if you keep folds open if you would, and just go to the core volume in P, MS 6110. It's the very last document behind numbered tab 11, which I'm hoping 6110 should be a note on the updated statistics.
Sorry, could you give me the page again?
Yes, 6110. It's behind tab 11, if that's an easier way of getting there quickly.
Am I misreading this, Sir James? Does it show there are a lot more ECRCs than CRCs?
It does. I think everyone...
An enormous lot more.
An enormous lot more, because everyone applies, when the roles are opened up, as it were, you apply to get the soft intelligence as well if you're entitled to.
Right.
But I think that, my Lord, that's the right place to focus, I suspect. So it's a lot more interesting, perhaps from everyone's perspective, to be focusing from halfway across the table to the right-hand edge. And what you see is very significant numbers of ECRCs issued. And of course, they can be issued every time someone reapplies for a job or the post changes or whatever. But millions, upper part of 3 million towards 4 million. And then those where there is a conviction or caution identified pre-filter, well, there you're around the 300,000, 320,000 mark. And the result of the changes, which I'm going to come to in due course, is the next column. In other words, the penultimate column, the second in from the right-hand side.
Yeah.
So you'll see, in effect, that a third have gone. So the effect of the changes, if you wanted to know what the effect of the new amendments to the legislation was, and Lord, I'm so sorry, I'll get Lord Sumption there, it's 6110.
That's the MS number, yes.
Thank you.
That's the MS number. And I was just saying that the chart is most interesting if you ignore the left-hand side, as it were, start halfway across where it says ECRCs issued. You see the very significant numbers that are issued. The next column, ECRCs in which caution or conviction identified pre-filter, 300,000 odd, a little bit over. That's any bounce back. So that would be the old system in effect. And then as a result of the filter, in other words, as a result of the legislative amendments post-T, a third have gone. They're now filtered out.
You made the point, Sir James, that with ECRCs, there's an exercise of individual consideration given at least where there is the possibility of adding soft intelligence.
Yes.
How does it work in practice? Are all the ECRCs individually considered?
There are some figures on that which I'm going to come to.
Right.
Not quite sure I've got them in my notes at the moment, but I am going to come to them. And the punchline is going to be that because Mr. Southey makes a point about that, and his point in essence is, where's the dice in all of this in an individualised scheme, because chief constables do it all the time in relation to soft intelligence, so why couldn't you just extend it out a bit? And I think the statistics, and I haven't got them collected here rather inconveniently, but I will come to them, I think they're in Mr. Ray's statement, indicate that the number of occasions on which soft intelligence is actually included in an ECRC, so it doesn't tell you how many times it was considered,
right,
is roughly 10,000. I mean, it's 9,000, so it's a very small number actually where it's included.
That's what you'd expect, but what I was wondering was whether at some stage we're going to find out whether each one is in fact individually considered by somebody.
Well, I think it would depend upon there being reactive soft intelligence in the police's systems and then consideration. But I'll come to that if I may.
You have to at least ask yourself the question whether there was.
Yes.
Yes.
I mean, there has to be individual consideration to the extent of establishing whether there exists soft intelligence.
Yes, but that could be automated, at least in the first instance.
That may just be a flag on a computer.
I'm pretty sure it is, and then you and there's some material in relation to that, and because of the way that they search, you get quite a large number on that. But that's principally because I think I'm right in saying that's principally because they search across a range of different names around the edges. So Jones spelt various different ways, if you see what I mean. So you get a big number of hits back, but out of that, a very, very much smaller number of cases where they actually consider yes or no.
But where there is soft intelligence in existence, does it not require individual consideration of those cases?
Yes.
Which include soft intelligence?
Yes, under the scheme, it does. That's ECRCs.
That's what has to consider.
So that at least gives you some favour of the scale of the change, the scale of the sort of issues we're dealing with, and you saw the emphasis in the Sunita Mason reports on automated system and how all of that works. Can I just turn very briefly to the process of change before coming to the new legislation and the nature of the changes actually made? But so far as the process of change is concerned, draft orders were laid. They were, I think, debated in both houses, affirmative resolution procedure made on the 29th of May 2013, and their effect was to amend the 1997 Act, pursuant to the enabling power in 113A sub 7 and 8, so in effect a Henry VIII clause, so far as the Police Act is concerned, and to amend the 1975 order to create the same effect into that territory. if you want a description of the process of change, you have it in folds 1, paras 29 to 33, and that is at 1271 in the hard and 7394 in the electronic. So far as the nature of the changes are concerned, what in essence happened was that you now had built into the legislation a set of new rules so that only a selection of cautions and convictions that have been spent are now disclosable under the new regime. There's in effect a parliamentary selection as to how the more nuanced scheme required by the T judgment should be set up. There are, of course, already some filtration, some detailed rules having a filtering effect by reference to the general position so far as spent convictions is concerned in the 1974 Act, exceptions in relation to a specified, but only in relation to a specified range of jobs, with all the parliamentary judgment surrounding that as to whether or not their suitability requires a truthful answer in a nutshell. We saw the list of examples at Lord Wilson, Para 7 in T. And then you have questions around what type or nature of information should be available, and that's the subject of the new legislation, section 113A, which is no doubt beautifully put together, but not entirely easy to follow immediately. It's in Core Authorities, Volume 1, Tab 2, page 32. I should have said that before you get into the intricacies of these changes, you still have the only differentiation on which I relied last time in T, which was the recordable offences ones. You've still got that. And now you've got more filters, as it were, built into it. So if I can try and summarise where this all ends up, and I'll show you the provisions as we go. And I'm going to start with the one conviction group. So there's a set of rules that govern what happens when you've only got one conviction. And if you've only got one conviction, the conviction has to be disclosed. I'm going to come to caution separately, but the conviction has to be disclosed if it is current. So the first grouping under one conviction is any current conviction is group 1. And you find that in 113A sub 3 sub A on page 33. To start off with, a criminal record certificate is a certificate which gives the prescribed details of every relevant matter. And it's every relevant matter that is the governing concept relating to the applicant which is recorded in central records. And then you go to 113A sub 6, which starts at the bottom of page 33. And the relevant bit of it is the definition of relevant matter on page 34. And you see the reference at A3 on page 34 to current conviction. And if you want to know what a current conviction is, you then go to sub 6 capital E on page 36, little c. So the position is that we've now got, under the old scheme you'll recall, they could be spent under the periods of the 1974 Act, but all convictions were disclosed irrespective, and you now have a limit on that. You now have a currency limit on that, introducing an overall time limit in effect. So it's only current convictions and cautions, and current is defined in the nuanced way that we see in little c on page 36, and it depends on the age of the person and on the age of the conviction or the caution. And so once it is spent under these provisions, or once it's no longer current under these provisions, then it's spent in its entirety, even for the purpose of this regime, subject to the special rules to which I'm going to come. But what it does is to provide, as it were, for the one conviction group, a limit. And it's a limit which is based on both the age of the individual and the age of the conviction. And that's the basic default position under this new regime, subject only to the exceptions that I'm going to come to. But that overall limit applies. You see there are different rules in relation to cautions and convictions, as you see between C and D on page 36. But their structure is essentially the same. It's just the numbers that are different.
Where did those periods come from? Did we see that somewhere?
Those periods, I think, are explained in Miss Fold's first statement. Don't invite you to go back to it now. Para 38, Appendix 2D, 1274 in the hard copy, 7397 in the electronic. But it's Fold's 1, Para 38, that explains how they got there. Not sure it was terribly scientific, but
I see, yeah.
you have to select an age, you have to select a period. But they are drawing lines, therefore, as I say, on the basis of the age of the individual.
Well, this is the clearest example of a bright line which you'd rely on.
I'm going to be saying bright line as little as humanly possible, but it will be inevitable. Yes, it is.
It's not the only one, is it? Anyway, you're coming.
It isn't the only one. We've got a succession of them. But at least this one has, this as it were, is the basic scheme for the one conviction group. It differentiates on the basis of the age of the individual. It differentiates on the basis of the age of the conviction or caution, and is subject only to the limited exceptions, or to the exceptions, which, and it's the exceptions, of course, which create the hard cases here, because those age limits and those time limits do not apply if you fall within the exceptions. And that's these cases in effect. But this is the default position and distinguishes or differentiates on the basis that I've described. So that, we're still in the one conviction group.
Well, it's one conviction of particular types, isn't it? Anyway, go on.
It's one conviction.
Well, you started at the bottom.
Yes.
But you're going to go up, aren't you?
Yes, I did. I'm going to go up. Then you've got any non-current, or for this purpose spent, slightly different sense of that word, conviction for what Parliament decided were properly characterised as more serious offences. So even if you fall outside those time limits, the offence still has to be disclosed and will still be disclosed if it's of the more serious kind, still within the one conviction group for the moment. So it doesn't matter if it's spent for this purpose, this is the exception. If it's more serious, it always gets disclosed. And that second category under this one conviction group, any non-current falling within the serious offence category, you find from, the bounce is pretty similar, but it's 113 capital A sub 3 first of all, give the prescribed details of every relevant matter. Then you go back to sub 6, which starts at the bottom of page 33, and you go into the definition of relevant matter. And for this purpose, it is A1
For 6D offences.
Yeah. It's A1 and C, so it's conviction for an offence within subsection 6D exactly, and then you've got the same position in relation to caution at little c halfway down page 34. So that takes you into 6D, exactly. And 6D therefore addresses the question, what should be the serious offences for the purpose of this regime? That's what 6D is in essence doing. And that's not an uncomplicated task, perhaps, if you're trying to identify those out of the statute book. But what in essence this does, 6D, is to group together offences which obviously appear to the legislator to be particularly relevant for the purpose of suitability of various persons to work in the sectors to which this regime applies. So one sees, for example, at the bottom of page 34, 6 capital D little d, an offence specified in the schedules of the disqualification from caring for children, England regulations 2002. And then for the more general offences, the technique that is used is in E, at the top of page 35, an offence specified in Schedule 15. I warned you it was complicated, but...
there are now 3 Schedules 15 to the Criminal Justice Act, but this is the original one, isn't it?
I think this is the original.
We've got 15, 15A and 15B. I think we got that somewhere.
We have got that somewhere. It's in Authorities Bundle 4, tab 36, MS 1238. And for the purpose of these appeals, it includes, at paragraph 20, ABH.
Right.
So they've used this as a proxy for seriousness. If
Can you give me a page for that?
Yeah, I'm sorry, my lord. It's 1238. I'm not sure whether that's the para 20 reference or the start of it.
It starts at 1232.
Yeah, that's para 20, I think, 1238. So I think when we come to it, the two lots of offences with which you're concerned are ABH and the sexual offences of which Mr. Owens, for which Mr. Owens' client was reprimanded.
What, in short, is the purpose of Schedule 15 in the context of the Criminal Justice Act 2003?
It's to specify offences for the purposes of a characterisation as dangerous offenders for sentencing purposes, I think under Chapter 5 of Part 12 of the Criminal Justice Act.
Not sure about the numbers, but the rest is certainly right. It's linked to the introduction of the vexed sentence of imprisonment for public protection, but not only.
Yes. So they've taken it as a proxy. They've taken it isn't, as it were, directly created for that purpose. They've used it as a proxy.
Does it, I can't remember, I ought to know, but I can't remember. Does it include any drugs offences? Which I only raised that because I noticed that Mrs. Mason had addressed them in some of her discussion documents.
She did. Can I check that
Don't
and get
worry,
back to you?
I can check it.
Well, no, I'm sure we can find
I've
that.
got a feeling it may not.
I'm sorry, I don't know off the top of my head the answer to that question. But as to the inclusion, so that's the basic structure of that. As to the inclusion of ABH specifically, and why that was considered to be suitable, with common assault not being covered, but that's the dividing line that's been drawn for good or ill. But the justification for that, or the reasoning behind that, so far as one can glean it, can I just give you a reference without inviting you to turn it up again? Folds 1, paras 39 to 44. This is on why ABH included but common assault not. And that's in 1275 and the hard copy, MS 7398. And especially para 40, explaining why ABH is covered in common assault not. It was a matter specifically considered by Mr. Justice Simon, as he then was, but because that was the case he was considering, and again, I'm not going to invite you to turn it up now, but to give you a reference on that, ABH included common assault not. Authorities Bundle 2, tab 8, MS 488, at paragraph 50 in the judgment of Mr. Justice Simon.
Seems to have been based, in part at least, on the CPS guidelines for preferring the charge. you look at folds 40, ABH should generally be charged where the injuries and overall circumstances indicate the offence merits clearly more than 6 months imprisonment. That's to distinguish it from common assault, presumably.
Yes.
Whether that is actually the basis on which assault occasion actual bodily harm is charged may be a different matter. Anyway, that's the basis. That seems to be what they...
It is. So it's the basis of the charging decision, but on the basis of seriousness.
Fine.
Appears to be the thinking.
Yeah.
Again, no doubt one can do these things in a variety of different ways. You can make the judgment between common assault in, ABH out, don't have any ABH. And you'll remember there was a great big debate around theft and whether that should be included, and that wasn't mandatorily serious for the purpose of this regime. So that's the second. It was still under the one conviction. We've had one conviction. It gets disclosed if it's current. It gets disclosed if it's a serious offence for this purpose. And it's disclosed if it is a conviction which resulted in a custodial sentence. So one conviction, but a custodial sentence always gets disclosed. And you find that from, I'm not going to go through the initial stages of the bounce because you're familiar with it now. If you go back to page 34 in Core Authorities, Volume 1, you will see that this is dealt with at A Roman 2 under relevant matter. So page 34, relevant matter and its definition. We're now within A Roman 2.
And somewhere we've been told that includes a suspended sentence.
You have, and I think you get that from 6 capital EE.
Yes, I think you probably do.
With its reference back to the next bit of legislation that you don't have to go back and check, but I'm sure my Lord is right. But that's the final part of the bounce. But that's a special rule based on disposal, therefore. So that's one conviction. It has those 3 categories underneath it that I've described. If you have more than one conviction, the second big group, as it were, and there is then disclosure if there is more than one conviction, whether it's current or not for the purpose of this scheme, whether it's within the definition or currency is expired or not. And that is go back to relevant matter, that's B on page 34, in relation to any other person, any conviction. That gives you the double conviction rule, whether spent or not, whatever the nature of the offence, whatever the disposal. But you will note that it doesn't include cautions under this rule. So it isn't a double cautions rule. And even if you've got 2 convictions, what has to be disclosed is then any conviction, not any caution. So if you had a caution, you've got 2 offences, 2 convictions, and a caution. The caution only gets disclosed if it's current, because it then falls within D. It doesn't get disclosed automatically, even if spent, under B, because that only applies to convictions. And this part of the scheme, and the way in which it's set out, can I just show you, just so you're aware of it, and again, maybe a quick flick would be of use, but perhaps not now. Miss Folds did a second statement, a relevant second statement for the purpose of this appeal, and that's in Appendix 2E, so not the one we had, which was 2D, but 2E. And her second statement doesn't have the number on it, but it's 5th of June 2015. That's in electronic 7653 electronic, and 1530 in the hard is the first page of that. And she deals with the 2 conviction rule, explaining justifications and thinking behind that between paras 20, particularly between paras 20 and 25 on 1535 in the hard, 7658 in the electronic. I just invite you just to cast a brief eye down those paragraphs.
She says it's a different matter if it's resulted in a court conviction on more than one occasion, but it's not the number of occasions, but the number of convictions that matters for the...
It is the number of convictions. And there's obviously a concern about pattern of offending here.
She goes on to that in the next paragraph, look, 21, did
Yeah.
not make an exception for multiple convictions out of the same set of
Right.
circumstances, etc.
Quite. But the basic themes and concerns, there's obviously a pattern of offending concern. There's also the precautionary approach concern, which you saw reflected in Sunita Mason's reports, given the lack of an evidential base, lack of a clear evidential base for this sort of thing, the precautionary approach. And one sees that from folds 2, para 12, a few pages back.
Is anyone attempting to obtain an evidential base?
I will check.
Oh, it would just be interesting to
It
know.
would.
Or at least how it might be gone about.
Yeah. Yeah, my lady, I'll check that. And there are, I said that there were concerns about that lack of an evidential base, the precautionary approach, obvious concerns about patterns and so on, but also linked into this, the concern that the scheme had to be workable and sensibly and efficiently and practically workable across a pretty big number of potential cases. And that's the theme that she then goes on to. If you're at the end of para 25, you'll see that the next little section is all about numbers. So there's obvious concern about that. But that, in a nutshell, is how the legislative scheme now works. There's now the two-conviction rule, and that's particularly the subject of Mr. Southey's client's appeals, the P cases. And then the final part of the piece is perhaps cautions.
Could you just point us in the direction of where a recordable offence is defined? I mean, that's been there for a long, long time, but so it's not a change, but it would be nice to know where we find it.
It has. Again, can I ask? Then regulations. We'll get that. I'm pretty sure we had that because we had it in Gochran.
We did.
So I'll find it. Cautions. The position in relation to cautions is that current cautions are disclosed. See page 34 under relevant matter at little d, halfway down the page. And we saw how they are defined at 6 capital E over on page 36 at little d. And so you see that what's been done is to differentiate between cautions and convictions for this purpose, at least in terms of the timing, because the period for currency in relation to cautions is shorter, in a nutshell, and it's shorter from the date on which the conviction or the caution was given, and it's shorter there's then the same differentiations we saw in relation to convictions based on the age of the individual on the date it was given. So that's how the currency of, so current cautions in that way are disclosed. That's the first bit of cautions. The second bit of cautions is that cautions in respect of specific and serious offences are disclosed. And we see that specifically provided for in relevant matter at little c on page 34, which takes one directly into 6D, capital D, with the definitions of seriousness. So
it's the same list, isn't
same list. But as I pointed out earlier, and this is perhaps the third part of the piece with cautions, if your caution is spent under the ordinary rules, and they are not serious offence cautions, they don't get wheeled out under the two conviction rule. Because the two conviction rule only applies to convictions, as we saw by the letter small b on page 34. So, I'm sorry for that rather convoluted bit. It's now going to be more submissions and tracing through the legislative scheme, but it's, I hope, helpful to group them in that way so that one sees how the legislative regime actually works in practice. But so the position now is, as a result of those legislative changes, that the regime no longer, as it did in T, when this court was considering the issues in T, it no longer applies to all convictions or cautions. Parliament has grappled with the judgments surrounding this more nuanced scheme and has, it appears, adopted the precautionary approach, at least in relation to the two conviction rule. By precautionary, I mean one which leans towards disclosure with all the public interest aims and benefits of information provision in this context, in relation to these sorts of roles and jobs. It's created a scheme, as we've seen, that for all its complexity undoubtedly now does differentiate between children and adults, between convictions and cautions, between more and less serious offences, between more and less serious disposals, and on the basis of periods of time since conviction or caution. We have then that legislative regime mapped in effect in its entirety into the 1975 order. The 1975 order obviously has different effects, which was the subject of some discussion in T, it being closer to the relationship between employer and employee, but by and large those substantive changes are mapped over into the 75 order. And the impact of the changes we saw in that schedule at, I think it was 6011, or in the core volume, remember the table. But we saw, in summary from that it's had quite a significant effect. In a nutshell, a third of what used to be disclosed has now been filtered out at this stage. But you still have a very large number of cases going through the system in England and Wales. The position may be otherwise and different in Scotland and in Northern Ireland, but at least in England and Wales, one has a very significant number still going through the process. But the bite of this additional set of filters has been, in effect, to take a third out. And of course, there are balances associated with that, maybe a good thing or a bad thing or an indifferent thing. The more you tweak the system down, as it were, the more you create the capacity, at least, for relevant information not to flow into the safeguarding system which it's designed to protect. Likewise, if you go too big, then you end up with appeals of this description, with people saying, well, that's unduly interfered with my Article 8 rights. But there are overall balances that need to be struck. I'm not going to look at that now. While still on the scheme, a couple of other areas to deal with. Firstly, it isn't a bar to employment. We are not here dealing with a barring regime. You know from cases you've considered in the past, there are some areas where the legislation is set up so as to bar individuals on particular bases from entering employment. We are here dealing with a disclosure regime. And in that respect, there is a DBS code of practice which refers to which registered persons, that's those persons who have to administer the regime, have to comply with. That is dealt with in Folds 1, para 47. I just invite you to take up Appendix 2D again just to show you those. Para 47, 7401 on the electronic, 1278 on the hard copy. And you see para 47 referring to the code that is applicable to employers and other bodies required to deal with this. And the code itself, I'm told, I'm getting whispers from Mr. Southey, I think, and others that this may not be the most recent, and perhaps its date will reveal that anyway, code of practice, but here it is anyway, exhibited to Ms. Folds' statement at 1478 in the hard, 7601. At this stage, at least, 1479 or 7602 in the electronic, you will see in the penultimate bullet on that page, registered bodies treat their applicants fairly when considering sensitive disclosure information. And then the final one, those who fail to comply with the obligations may be suspended or deregistered. It's got to be checkable, as you see from point 6 on the next page, 7603 or 1480. And there's a requirement on registered bodies at the bottom of that page, 1480 or 7603, for people to have a policy, secure handling and so on, and then a suitability policy referred to over the page. And so that's the code of practice as it then existed. And this theme is picked up again in...
There's no guidance as to the actual assessment of the information.
There isn't, beyond the bare requirement that it should be done fairly, yes, and the requirement that these sort of people should have policies themselves. And you see an example of those policies in Miss Folds' second statement. So that's, I'm afraid, in Appendix 2E. And the relevant paragraphs for our purposes are 30 and following. And they are 1537 in the hard and 7660 in the electronic. The various examples of policies that have been produced, and the points that Ms. Folds seeks to bring out from that, perhaps the final sentence of para 30. She cites the examples, and then para 33 on page 1541 or 7664. para 33, and para 36. We'll come back to the significance of this, but again, some of you at least will recall we've had, in the long-running litigation that surrounded this subject, there has been quite a lot of debate around the reaction of employers and what one can assume about how they're going to react, and picked up as long ago as the L case in relation to whether or not there was an interference with Article 8 rights. But it is at least a part of this scheme that some information, some judgments are expected to be made and will be made by employers. They will, for example, have the best idea of relevance, what role is being sought to be filled, and so on. But that's the evidence in relation to that. And then, of course, final part of the scheme, one has the ECRC scheme, and you know that you know how that works. From it's 113B. And as I understand it, I'm not sure quite where this has gone. It's not a case of mine, but I think that some issues surrounding that are already before this court in a case called AR.
It's a case of AR.
Yeah. So I wasn't planning to go through that in any great detail. It perhaps isn't central for present purposes other than to know that it exists. And there were some issues below, as you've seen from the court's judgments below. But if you want a description of that scheme, it's perhaps most conveniently described in the statement of Samuel Ray. I don't invite you to turn it up now, but it's in Appendix E, 2E, starts on hard copy 1583, electronic 7706, and the relevant description is in paras 12 to 22 of Ray. Individual decisions by chief officers, guidance to seek to ensure consistency of approach and judgments and so on, and a system of reviews now carried out by an independent monitor if they disagree with the inclusion of by the chief officer. But that sits there as a necessary and integral part of this scheme, but it isn't the central focus of this set of challenges, which are centrally focused on those rules that we've seen in 113A. With that description, my lady, my lords, if it would be convenient, I was going to move to in accordance with the law. And the approach in principle. The first submission we make in relation to the approach in principle is that the basic description of the requirement that a legislative scheme be in accordance with law and the rationale for that basic grouping of principles in that description were set out authoritatively by Lord Bingham in Gillen. And they have been echoed in pretty similar terms by the European Court of Human Rights. Rather than turning it up in the raw, if you still have the T case to hand, and recognising, as I entirely do, that Lord Wilson dissented on this issue, in other words, on the in accordance with law issues, can I take that as a convenient reference to what Lord Bingham said in Gillen, paragraph 30 of Lord Wilson, on, so bundle 3, tab 21, MS 871. It's a pretty well-known passage. I know my lords. I think my Lord Hughes in his the judgment about port stops referred to this, and we had a consideration of Gillen, and my Lord Sumption referred to it also in the Cat case, I think. But you see, if I can invite you just to remind yourselves of what was said both by Lord Bingham between C and D on page 871, and then the correct statement by Lord Wilson that the European Court, although disagreeing on the outcome, didn't disagree with the enunciation of legal principle, as is evident from the quote from the European Court that he then sets out between G and H. Could I invite you just to read those two quotations?
Do they ever explain what they mean by arbitrary?
They never do.
Because that's the key word.
It is, and they never do. It gives them the delightful flexibility to decide one case one way and another case another.
Arbitrary isn't simply an expression of disapproval. It's
A higher standard.
it's a description of a situation in which an official has an excessively wide discretion to do what he likes, so that you cannot tie him down to any sufficiently clear rules. Therefore, you can't assess the proportionality of such rules because there aren't any.
My Lord, you're right, and the question that we have to confront here is not the one that normally arises in the context of secret surveillance and telephone tapping, Malone onwards, which are to do with individual discretion inadequately controlled in that very special circumstance, but it can arise in other circumstances where you have unconstrained discretion. But it's how that applies in a context where you have the lines being drawn by a legislative scheme in this way. And it bounces ultimately into the question whether that scheme needs to be individualised or to contain some capacity for individual review. Or whether
That's why I asked you what arbitrary means.
Yeah.
What it doesn't mean is capricious.
It has that flavour. It means...
Well, surely, my Lord,
capricious
Thompson is right in saying, in its true connotation in this context, it means that it's not accompanied by a sufficient number of, whether you call them rules or safeguards or structures, to allow the discretion to be managed, so to speak. That's the essence of it, isn't it?
It is in relation to a legislative structure which confers an individual discretion on an officer.
Well, it goes a bit further than that, doesn't it? Because one possible view of MM is that what they were really concerned about was not the output, but the input. In other words, they were concerned that although in certain circumstances what you had to disclose was everything that you had, what you had was itself a question of discretion because there were no sufficient controls over the information that police forces in particular sought to retain in their records. I mean, it's obviously a consideration primarily relevant to 113B. In a case where there's no disclosure, the problem, like MM, and the problem is the prospect of disclosure. One of the problems, possibly the main one, is that there's no control over what ends up in the category of disclosable material, and therefore it's not much comfort to be told that there are rules governing when it can be disclosed.
My Lord, yes, I'm not going to disagree with that. Sometimes they use, and we see it in the judgments in T, faithfully reflecting the judgment in MM and earlier judgments, the problems, and I'm going to come to this in the description of all my submissions in relation to the principles, but the same thought is encompassed by reference to blanket and indiscriminate.
My lords, ladies and gentlemen, Her Majesty's government has asked that the nation observe a 1-minute silence at midday in remembrance of those who lost their lives and were affected by the Finsbury Park attack that took place 1 year ago today. As the time is now approaching midday, we kindly ask all those in the building to stop what they are doing and prepare to mark this moment of remembrance. I will announce when the minute is over. It is now midday. 1 minute has passed. Thank you for your mark of respect.
My Lord, I'm sorry, I was saying that the same thought is leads to trouble in the Strasbourg and to some extent the domestic case law. If you end up with a regime, and it may be the same thought expressed slightly differently, which can properly be characterised as blanket and indiscriminate. So that was the language that was used in the prisoner voting cases, if you'll recall, in Scopola and all of that. And there are other cases of the same type which I'm going to come to.
The problem is that all rules are blanket rules in relation to the category to which they apply, so that the only relevant question is whether the category is a sensible or lawful category.
It is ultimately. And so it might be thought that's not a terribly helpful set of adjectives, but the fact of the matter is that they continue to use it as a yardstick, and it may be that all it is actually doing, because I entirely see and agree with my Lord's point about it being blanket and indiscriminate in relation to the group to which it applies. That was the point you made in the Chester case in your judgment about how it made the slightest bit of difference. If it was 1 month, 6 months, it was still blanket and indiscriminate, but simply within the group.
How broad is the category?
It's true.
How far is it related? The problem might be.
It's true. But the, as I say, we'll see it in due course, but there are perhaps a much more difficult set of questions about how these principles work in the context of a scheme which is set up with, as it were, structural controls rather than on an individualised basis. And you have got two slightly different beasts in play. One of them involves the conferral through legislation of a discretion on the executive to do a certain thing.
That's, you mean, 113B?
Well, that's 113B, or it's interception or surveillance or Gillan to some extent. And the question then is, have you got sufficient controls in hard and soft law to contain that individual discretion? And then you've got the second beast, as it were, which is what happens when you set up a scheme which has got to cover a pretty big range of cases, a large number of cases, and what the legislation does is to set structural lines, for want of a better phrase. It doesn't set it up on an individualised and discretionary basis. And the question there is not quite the same as the question, how are we controlling the individual discretion, but you can see echoes of their case law on the individual discretion lines into those sort of structural questions. And it may be that those, a similar sort of set of principles applies in that structural context to ask the basic question, are the lines that have been drawn reasonable or adequate for the purpose of protecting against, and then you use whatever adjective you want, arbitrary or unreasonable interference with rights. But they are slightly different things, and the reason that they're slightly different and that the distinction may be of a little importance at least is because you know, and I'm going to come to it, that there was, at least in T and to some extent still here, something of a vexed question about whether you properly analyse those sorts of issues in accordance with law or in accordance with or under necessity. And there's quite a big difference, because if you're setting up the scheme structurally and you're asking questions like, should ABH be a serious offence? Should the line properly be drawn to include common assault but not ABH? Should it be a 2-conviction rule or a 3-conviction rule? You inevitably have questions that engage legislative judgment. Of course, within reason, bright lines within reason, per Lord Wilson and Matheson. But at least there you recognise that there is an area of judgment for the legislature properly to decide how those lines should be drawn. And so that it may be at least wise to recognise those two slightly different beasts and the slightly different treatment of them under the Strasbourg case law. But that's going to be the
bright line rules will result in a category to which the relevant rule applies in a blanket fashion, and in a number of cases to which, looking at the matter individually, we think they were not sensibly included. That's just a characteristic of bright line rules.
It is.
And yet it's clear that there are some circumstances which bright line rules are okay.
It is. And normally when you're talking about bright line rules, of course, per Lord Wilson and Matheson, the penumbra starts at a certain point. And so there is a limit to you can't just turn up and say bright line rules and that excludes the jurisdiction of the court to examine the reasonableness of the protection. But bright line rules and that set of structures do engage judgments, ABH versus common assault, classically. And in those circumstances, it seems very odd, despite its theoretical attractions, as it were, to take Lord Reed's reasoning in T at least too far. Of course, legality engages ultimately a binary question. Is it lawful or is it not? Have you exceeded the bounds of reasonableness? But when you're analysing the essential and different, and in our case, quite complex components of the scheme, at every level, there are judgments to be made about what should be included. And the question is whether it is appropriate for this court to accord any or no respect to the judgment of Parliament at that level. And my respectful submission is that there's nothing inconsistent with the judgment of this court in T in affording, in a nuanced scheme of the kind that we now have, the sort of respect to Parliament that would be engaged if one analysed those under the necessity head as opposed to under the legality head. I've jumped ahead a bit. I've probably made all 7 submissions in one go already, but that's essentially where we're going. So the first one, come back to the beginning, the classic elements of legality, what we all understood legality to mean before this set of issues started being explored and the subtleties explored in MM and T. Lord Bingham and Gillen, and they're the well-recognised ones. Is there a basis in domestic law? Is the law adequately accessible, so you can't have it hidden away? And I immediately put in brackets next door to that, unless you're in a secret context, where to reveal the controls would be damaging to national security, but subject to that, it's got to be adequately accessible, and it's got to be cast in a form which is adequately foreseeable, with the benefit of legal advice if necessary, all the way back to Sunday Times. So sufficient precision for the citizen to regulate his or her conduct with the benefit of legal advice if necessary. Those were the classic elements of lawfulness under the convention scheme. And that, of course, doesn't set its face against the conferral of discretions, and sometimes the deferral of pretty broad discretions on the executive, but it does require clear, publicly accessible rules that govern, and it requires, and this is, as it were, the initial limit of the focus on the substance of the law, it requires sufficient legal controls to avoid what is consistently described without definition, arbitrary action. And that, of course, can be a combination of statutory control and public law, as we saw in Gillen and the Begel case. And it can be a combination of hard law and soft law. But the rationale, the underpinning rationale was always the same, whether it's the European Court in Paris 77 in the quote you just looked at, or it's Lord Bingham in Paris 34, it is to provide a measure of legal protection against arbitrary interferences with rights. And that analysis of Lord Bingham was applied by and cited by Lord Sumption. The rest of the court agreed in the Cat case at paragraph 11. Cat is it, I don't invite you to turn it up now, but for your reference, it's bundle 7, tab 70, MS 2451, para 11. So that basic description of in accordance with law and the rationales for that set of principles set out by Lord Bingham in Gillen, that's the first point. The second point is that the question whether the law contains adequate safeguards has at least its origins in the context of secret measures of surveillance, and is particularly therefore focused on the adequacy of control of executive discretion. And all of those cases relating to secret surveillance are all about that. They're all about whether or not you've got sufficient control of the intrusion that all national authorities have to commit in order to protect the public in the secret world of the security and intelligence agencies, in a nutshell. And you've got a raft of case law, all on the same theme, all analysing different setups in different contexts of those types of control over executive action. It doesn't mean that the concept of arbitrary is otherwise broader than articulated by Lord Bingham and Gillen, so as to increase the degree of qualitative scrutiny of the law in question. Still less does it do so in a way that doesn't accord any form of respect to the different setups that there can be. The question is as to the adequacy of those controls. The third point moves to structures. So we're not now on executive discretion on the controls, but we're concentrating now on our sort of scheme where there is structural control in legislation. And the question is as to the sufficiency of the structure. Well, again, almost by definition, that's going to satisfy the classical elements of lawfulness. Basis in domestic law, adequately accessible, adequately foreseeable. All of those are going to be givens here. So the real question is, to what extent, in accordance with law and the principle of legality in the Strasbourg case law, gets interested in a legislative set of structures where those basic ingredients of lawfulness per Lord Bingham are in effect givens. And they tend to get interested, if one's looking for themes, I respectfully submit, when they can conclude that a legislative scheme applies on a blanket, automatic or indiscriminate basis. That's the mantra that tends to be used. But in analysing that set of issues around structures, one can point to any number of cases where that is the way in which they've done it, that's the language that they used if there is trouble for the state. So, I mean, to take but some examples, blanket and indiscriminate is the language used and the test applied in prisoners voting. Recognising entirely the point that my Lord Sumption re-put to me, as it were, based on his judgment in Chester, and indeed Lord Mance made the same point. It's always going to be blanket and indiscriminate to the group to whom the law applies. That was Chester, which is Bundle 2, tab 15, MS 712, and the two paragraphs of relevance to this point are Lord Mance at para 33 and Lord Sumption 136 to 137. But they still use that as the yardstick. Is it blanket and indiscriminate? If there is, there's trouble. It was the language that was used in Essen Marper, as you will recall, in the context of data retention and so on. And you had the relevant bits of Essen Marper, you perhaps get them most conveniently from the Gochran case, which is Bundle 2, tab 14, 618 at para 24, quoting the European Court in Essen Marper at 125. It's blanket and indiscriminate again. And I'm sorry, I should have given you the reference as well, because it's the language that's also used in the context of prisoner voting in the Scopola case. That was the Italian one in which the UK unsuccessfully intervened to try to persuade them to overturn Hearst, which they were remarkably unprepared to do, and led to the decision in Chester in this court. But again, it was blanket and indiscriminate. The interesting feature, it might be thought, of those cases, taking them as a group, is both that they use the language of blanket and indiscriminate, but also that at least in Strasbourg, they tend to worry very little about whether they analyse it under necessity or in accordance with law. So in Essen Marper, for example, they considered it under lawfulness, noted that the relevant statutory provision, I think it was section 64 of the Police Act or something, but noted that it was expressed in very general terms, and then said, but we don't need to worry about that. We're going to analyse whether it's too broad, whether it's adequate as a set of structures. We're going to do that under necessity.
They do care about which category it comes under, because they define what the difference is, what the criteria by which you assign it to one category or the other. And maybe that in particular facts, in some cases it doesn't make any difference because it fails the more exacting tests.
Yes, what I meant by not caring, of course they do, my lord is right, but what I've been trying to search for in the case law is the example of the case where the state sets up a legislative scheme with these sorts of controls built into the legislative scheme, rather than it being an individualised thing and rather than it being an exercise of individual executive discretion. And there, they do tend to, as it were, jump betwixt and between. So Essen Marper, they note the point, and they note the point about it being overbroad, and then come back to it under necessity. They note it, first of all, under in accordance with law, come back to it under necessity, and then their ultimate reasoning is outside the margin. So they're applying the margin, but it's still outside because the controls aren't adequate, having applied the margin. And they do the same in relation to prisoners voting.
It may be that the best analysis, recent analysis of this whole question is Lord Reed's analysis in Christian Institute and the Lord Advocate, where he identifies the two strands of in accordance with law. One, foreseeability of application, and two, protection against arbitrariness, which is specifically related in that analysis to the ECHR decisions about excessively broad discretions. And he then goes on to describe T as an illustration of that last proposition.
Oh yes, one can perhaps apply that to both the structures and the individual discretion. That would at least achieve consistency between the two. So I don't disagree with that, and it's no part of my case to invite the court, as you know, to overrule T. We simply say that T, properly understood, casts in accordance with law as a binary question, but doesn't exclude the possibility that margin could apply, or in our domestic analogue, respect or a discretionary area of judgment should apply to Parliament in deciding on the ingredients and precisely how you set it up. The fourth proposition that we advance is the entirely obvious one, that whether or not a scheme is to be characterised as blanket and indiscriminate, or as structurally incompatible, involves examining the components of the scheme and its design and all the elements of the design in their proper context. So considerable caution is really the punchline, perhaps, of this point, before reasoning that because they're not met in the context of one scheme, they won't be met where the combination is different. And that is perhaps most illustrated, or most clearly illustrated, by the Gochran decision, which I ought to take you to very briefly. It's in Bundle 2 of the authorities, tab 14, MS 607 as the first page. And this was a case, as you will recall, in which the challenge was to the retention of biometric data and other types of data by the state. And that was being done on the basis that information could be retained. There had been earlier challenges which didn't much like it applying to all information, and then the change was made so that it applied to permit retention in relation to all convicted people. That was the issue in a nutshell. And you see, well, just for good measure going through it, you see Essen Marper, which was obviously directly relevant in that context, being analysed and dealt with by Lord Clarke, who gave the judgment of the majority. I think Lord Kerr dissented in this case. But Lord Clarke gives the majority judgment, and Essen Marper starts being analysed, and its precursor in the House of Lords at para 23. And you see the European Court's judgment in Essen Marper being cited in para 24. And those were really the themes I was developing on the last point, if you recall. So the first sentence of para 119 in the quote on page 618, Court is struck by the blanket and indiscriminate nature of the power of retention, overly broad. And then 125, in conclusion, the court finds that the blanket and indiscriminate nature, because there it applied to everyone, fails to strike a proper balance between competing public and private interests, and the respondent state has overstepped an acceptable margin. So the implication is that the margin is applied. It's being analysed in effect under necessity, although earlier on the judgment they noted the overbreadth or the potential overbreadth on in accordance with law. And they come to it, they apply the margin, they say because it's blanket and indiscriminate, because it covers too wide a range, it doesn't strike a fair balance, and it's outside the margin that would otherwise be permissible. But that, I respectfully submit, is the true approach in the Strasbourg case law to this set of issues. And as I say, the issue there was, at the time of Essen Marper, it was everything, convictions, cautions, acquittal information, all the rest of it, and then it got tightened. And that tightening still left a pretty broad group because it was all convicted people. So that was the recordable offences thing. True it is that the nature of the interference could be characterised as it were, less intrusive, because it wasn't so much about use and disclosure at that stage, it was more about retention. But nevertheless, the sole tightening had moved from acquittal information and cautions and convictions to simply convictions with the, I think it was recordable convictions there as well, as we see from, and that was the basis on which they distinguished and said, well, it was fine. And so that's the basis on which they agree with Lord Justice Girvan, who gave the leading judgment, I think, in the divisional court in the case below. Look at paragraph 29. I agree with the divisional court that the, on page 619, para 29 at the bottom, ECHR was not considering the position of convicted people and then he cites again in para 29 from the European Court of Human Rights judgment in Essen Marper. And he obviously picked up particularly on that final sentence in the quote from 106 by the letter D on page 620. The only issue to be considered by the court, this was at the stage before it was amended in Essen Marper, is whether the retention of the fingerprint and DNA data of the applicants as persons who've been suspected but not convicted of certain criminal offences was justified under 8.2. And he emphasised, Girvan LJ emphasised those words, as you see from para 31 of Lord Clarke's judgment. He quoted the extract, italicised the words all suspected but unconvicted people. In my opinion, he was correct to do so. And then the analysis and reasoning and conclusion of the court is summarised in para 38 on page 622. And as he notes for good measure, when you get to para 45, he then analyses between 38 and, in the paragraphs that follow, he analyses the in principle justification of retaining conviction information. And then you see what he says about the prisoner voting line of cases, and indeed the animal defenders case at para 45. It's a point I'm going to come back to, but I particularly invite you to note para 110 in that quote from animal defenders. The margin of appreciation inherent, judgments to be made. Question is not, can you design some better or more restrictive regime, some regime which favours more the rights of the individual under Article 8, for example, than the public interest benefits. The question is whether you've fallen outside your margin in making those structural judgments. And of course that set of questions, with margin attached or without, analysed in that way, necessarily involves examining the choices made, both in relation to the individual components of the structure, as amended, and in relation to the overall balance of the scheme. And it assumes, well, it is obviously for the court to assess those, but to do so for the purpose of seeing whether the decisions made about those matters fall outside the range of reasonable judgments or decisions of the legislative kind that are inevitably involved. The court isn't judging and can't possibly be judging whether or not they're the only ones that could have been made, or whether they would have preferred to make them in some different way, ABH versus common assault. The question is whether or not the scheme passes muster or falls outside the margin, or, to use that language, it's properly to be characterised as indiscriminate and blanket. And that leads to the fifth submission, which is that the issue of principle as to the relationship between in accordance with law and the necessity tests cannot operate, we respectfully submit, to exclude the operation of margin when considering the individual components of a structural scheme of this kind. Of course, conceptually, their focus is different, but it's striking, going back to Lord Reid's judgment in T, how often that word focus is used. The focus of the two elements, lawfulness and necessity, is different. And one can, of course, see the purity of saying that the question whether there are sufficient safeguards is ultimately a yes or no question, and not a question of proportionality, so it's for the court to consider it. But it's also evident, we respectfully submit, that those in a context such as this, where you're looking at the structural elements of a scheme of legislation, it's also evident, as was squarely acknowledged by both Lord Wilson at para 32 in T and by Lord Reid at 114 in T, that the issues overlap and are interlinked. And we saw that they were absolutely right to acknowledge that, because it's a key feature of the Strasbourg jurisprudence, as one saw from the references to, for example, Essen Marper and the prisoner voting cases in Gochran.
So which paragraph of Lord Reid's judgment in T?
It was 114, my note.
114, yes.
He refers to focus twice, once by the letter H on 895 and again at 896 between A and B. The court's focus tends to be on that. And I respectfully submit that that must be right. If the punchline of this is as it's sometimes taken to be, and as it appears to have been taken to be by the courts below on some of these appeals, if the focus is truly on the question, well, if we have to analyse this under the rubric of in accordance with law, does that exclude any operation of margin or respect for the judgments that Parliament has made? If that's truly what is being said, and I'm not sure it is, Lord Reid is there, I respectfully submit, simply analysing the headline issue and the different focuses of legality as compared to necessity or proportionality. But if it's taken as that, I respectfully submit that would be wrong. And it would be wrong because, A, it's not borne out by the Strasbourg case law, which we've seen, which poses the question, is it blanket and indiscriminate, or is it inadequately safeguarding as a regime? It poses the relevant question as being whether you fall outside the margin. So the Strasbourg case law doesn't support that, and Harper, as you know, is Grand Chamber, and so are those prisoner voting cases. But secondly, and in principle, it can't coherently be a game of labelling. If the challenge is ultimately made to the reasonableness of the choices made by Parliament in a legislative scheme like this, there isn't any coherent reason of principle for not according respect to those judgments. It is properly, we respectfully submit, subject to the outer limits, are you outside the margin? It is properly for Parliament to make the detailed judgments about the various elements of the scheme, ABH versus common assault, how many offences, 2, 3, do you include another element of the scheme or don't you? To what extent should currency be 11 years for adults and 6 years for children, or 5 years for children and 10 years for adults? Those sorts of judgments are properly legislative judgments for Parliament for all well-established constitutional reasons that you don't need me to remind you of. That is why, to continue with the MARPA theme, that is why, if you recall, when the MARPA matter came back before this court in GC, it had taken a very, very long time for the government to react in a legislative sense to the MARPA decision. And so someone eventually said, well, we're fed up with this, we're going to challenge the operation of the continuing regime for the purpose of seeking a declaration of incompatibility and or striking down the policy of the police. And this court said, we will grant a declaration of incompatibility because you haven't complied with MARPA, but it's properly for Parliament to decide how the new compatible scheme should be set up. And we respectfully submit that that's entirely consistent with that margin continuing to be applicable in principle. And again, you don't need me to do more than remind you of that consistent line of authority in this court relating to the reasons why, in making judgments of a schematic or structural kind like this, the courts do accord considerable respect, to focus on the domestic analogue of margin, to the judgments that Parliament has made. You see it in the raft of cases from, I mean, I can take any number of cases in which that's been set out, to give you 2 or 3 and no more, and not invite you to turn it up because it would be too tedious to do so. But Lord Dyson in the Court of Appeal in MA, which became the Rutherford case up here, at paragraph 57, Authorities Bundle 7, tab 73, MS 2620, on the respect to be accorded to the affirmative resolution procedure. On the same theme, Lord Reid himself, in, I can never remember what the acronym is, but SG or JS, you remember the benefits cap case, we all remember it only too clearly, SG or JS, Authorities Bundle 9, tab 84, 3171 on the electronic, and the relevant paragraphs are 92 to 95, specifically on whether respect is to be accorded to the judgments of Parliament in affirmative resolution legislation. Answer yes, and explaining why that is so. So even if the ultimate question, the ultimate judgment, essentially asking about the sufficiency of the safeguards and their protection against arbitrariness, even if the ultimate question under lawfulness is a binary one, yes or no, for the court. And even if you choose to analyse this set of issues, in effect exactly the same issues as were analysed under necessity in a variety of different contexts, Cochrane, prisoners voting, S and MARPA, it shouldn't make any difference where you place it. You can perfectly happily say that lawfulness raises a binary question while still according proper and appropriate respect to the judgments that Parliament makes underneath that in relation to the detail of that structure. The sixth submission is that there is no support, we submit, for the proposition that any of the matters which are referred to in the cases as relevant to the, if you will, antidote for labelling a scheme indiscriminate. There's no support for the proposition that any or all of those matters are a sine qua non of a lawful scheme. The correct approach, I submit, is to examine the scheme as a whole. That's exactly what the European Court does, and indeed the Court of Appeal in our case correctly accepted that that was the correct approach at paragraph 40. But you don't look at the list of different ways in which the scheme could be rendered, as it were, less blanket, and then say they've all got to be complied with. Each and every one of them is to be viewed individually as necessary. So you look at the scheme as a whole and then you make the judgment, put it in context. If you go back to T, Authorities Volume 3, tab 21, and go into the judgment again of Lord Reid at paragraph 119 at 896 on the electronic. You'll see how he puts it. In particular, could I invite you to remind yourselves of the final sentence of that, quite a long sentence of that paragraph, over the page on 897. And the key word is cumulative. And that's not an accidental word, because if you go back to page 895, you will see that all the reasoning of the European Court in the MM case, and you'll remember the context of MM was disclosure in our sort of territory, but simply pursuant to the common law, so there was nothing. There wasn't even the 1997 Act regime, or if there was, it was only a twinkle in someone's eye and taken into account prospectively, as it were. But the relevant point for this purpose, if you go to 895 and you look at the quotation from MM, which is their dispositive paragraph in effect at 207, just by the letter B on page 895, the cumulative effect of these shortcomings. So Lord Reid has taken the word, correctly we submit, directly from the Strasbourg case law and directly from MM. And so one can't focus on that list that he gives. And I think Lord Wilson produced a remarkably similar looking list in his judgment as well, although he analysed it under necessity. Just give me one moment if you would. I'll find that paragraph. Yes, Lord Wilson's equivalent list is in paragraph 41, and you'll see he disagreed on lawfulness but came to the same, exactly the same analysis in effect under the heading of necessity. So his list is in paragraph 41 on page 875, A through G, round about the letter F. That's pretty much, or it's a similar looking list to the list that Lord Reid produces.
it must follow that some of the factors contained in the list may be missing in any given case, but the cumulative effect would nevertheless render the provision
My
incomplete.
lord, that's exactly the sense I respectfully take from it. Exactly that. And so, I mean, it's perhaps particularly sharp when we come to the issues about the need for an individualised scheme in every case, or the question of review, because you'll see that the last reference in the list that Lord Reid gives on page 897 is the absence of any mechanism for review. But my submission is, you won't be surprised to hear me say, given that there isn't one, is that you can satisfy, or you can avoid a characterisation as blanket and indiscriminate if you have sufficient cut in the legislative regime before that. And Gochran is an example of that. All they altered was conviction. And indeed, scopola is not a bad example of that either. If you recall, I can't remember precisely what the Italians had done, but they'd set up a
automatic threshold.
It was a little bit nuanced, wasn't it? But there wasn't, as it were, full-blown individualised
No
consideration.
discretion at all. The law
No.
simply said if you were sentenced to
Right, but one can look at any number of schemes in which the legislative setup is for the particular action to be taken on the basis of structural lines set by Parliament rather than individual discretionary determination. And one has an example in the bundles in the context of sharing of data in the context of the National Health Service and sharing of information between government departments. I think it was Health Service to Home Office, no doubt therefore for immigration purposes or something, but that was the basic structure, and there were structural lines after which the disclosure could be given, and that was cleared, as it were, as a process, even though there was no individualised consideration. In the W case, again, Lord Dyson, I don't think I'm going to invite you to turn it up, but for your note, it's in Authorities 2, tab 23. Just check if there's anything worth. It is perhaps worth turning that up. Sorry, could you briefly go there? Authorities 3, tab 23. You've probably got the same bundle open already, so it's not much of a leap. And just to show you, '76 and 77 on page 964. It's of some interest. This is Lord Dyson giving, I think, the unanimous judgment of the Court of Appeal. Yeah, I think it's a judgment of the court. So 76, you'll see the citation from MM. So he doesn't cite from MM in accordance with law. He doesn't cite from 205 to 206, the paragraphs we saw. He cites from 193. And that's classic Bingham, if I'm allowed to call it that. That's classic Lord Bingham in Gillen. And then he cites from Lord Sumption that I've already referred you to in Cass at paragraph 11. And considers the T case and my Lord Hughes' judgment to the same effect in Beggle. That was the one I was struggling to remember, but it was the Portstock case, if you recall. The seventh and final proposition, therefore, on in accordance with law, is that schemes that set, I keep calling them structural lines, but they are bright as well. Schemes that set bright and structural lines are, to some extent, an inevitable, but certainly an acceptable part of legislating. That is so is clear from, again, a raft of case law you won't need me to cite back to you, but Lord Wilson in Matheson, Authorities 2, tab 18, para 27, citing Lord Hoffman and Lord Bingham to the same effect. We've collated the relevant authorities on the acceptability within reason of setting schemes on this basis in our case at paragraph 60. and the principles recognise that there will be inevitably, we discussed it earlier, doubtful or difficult cases at the margins, but that the scheme can properly be set up because it's got to apply to a large group of people and therefore the generality is important, and it's got to be certain, workable, administratively efficient, consistent, and all of that. And those justifications for legislating in this way have been long recognised. Animal Defenders at para 33, Authorities 7 tab 66, MS 2332, RJM, very well known to the court I know, at paragraph 57 to the same effect, Authorities 8, tab 82, MS 3109. And of course, as we saw from the quotation from Animal Defenders that I showed you earlier on in Cochrane, that involves judgments, that itself. Where do you set the line? How bright should it be? How does one line interrelate with another? How do you set up that structure? They're all judgments. That's why the question is, does it fall outside the margin? And it shouldn't matter whether you analyse that under in accordance with law or necessity. And I respectfully submit that there's nothing inconsistent with the approach or the principles that I've put before the court in the MM decision, which was the one that was particularly focused on, or indeed Lord Reid's analysis of it in T. MM was simply an application of the basic principles to the particular facts then confronting them. And the reason it was considered to be particularly relevant in the context of T is because there was at that stage in Northern Ireland, in our very context as it were, the absence of any legislative framework for the collection and storage of data, the lack of any legislation relating to the retention and disclosure of cautions at the relevant time. The absence, in addition, of any independent review under the 1997 Act or the common law powers of retention. The lack of filtering arrangements under the 1997 Act, even pre the 2013 amendments. And those were the elements all set out in para 206 that Lord Reid quoted in T. And it was the cumulative, back to that word, effect of those shortcomings, as we saw from 207, that was problematic. So those are the submissions on in accordance with law. I can be very, very brief on the submissions of the approach in principle in relation to necessity and proportionality because they're very well known. It's entirely clear what the approach would be if you analysed it under that. There would be, undoubtedly, margin, respect for parliamentary judgments about each of the elements and about the overall balance. It would be relevant that there was careful consideration of how the scheme should be set up beforehand. The margin would, it might be thought, be at least tolerably broad because we're dealing with a very large scheme, legislative judgments, social issues, a balancing of interests. We're dealing with affirmative resolution. See Lord Reid's judgment in SG or JS at 92 to 95 that I referred to earlier. In short, you go straight to the Cochrane analysis, assessing the scheme, assessing the reasons for setting it up as Parliament has chosen to do, according margin, and then essentially asking the question, has this scheme become sufficiently nuanced to avoid characterisation as blanket and indiscriminate? The prisoners' voting question, the Essen Marper question, the Cochrane question. And remember, in Cochrane, although of course I accept that the interference was different, in Cochrane it was enough that it had simply moved to conviction. There was nothing like the degree of nuancing that we have here. And moreover, the submissions that I'm about to make about application of the principles to the present context would, I very much suspect, be not merely similar, but exactly the same whether I was making the submissions under necessity or in accordance with law. That was really the thrust of my point about it can't all turn on the labelling. Can I then turn to the application of those principles in the present context? And if I blur the necessity and in accordance with law submissions, you'll forgive me, but I'm going to make one lot of submissions on the application. The first submission is that the objective behind our regime, the regime that is before the court for its consideration, the objective behind it is, as Lord Wilson correctly characterised it in T at paragraph 40, supremely important. The need to protect children and vulnerable adults, amongst others, is of the very highest order. A failure at the level of structure could have very serious consequences, and most of these changes followed the Bishard inquiry into the murders by Ian Huntley, as you will recall. That importance establishes the legitimacy of the aim, but it also provides the essential context in which Parliament legislated and then came back to all of the balances and judgments inherent in the scheme in the light of the dialogue with the courts in the T litigation. And a precautionary approach, bearing in mind the importance of that objective, is, we respectfully submit, perfectly acceptable, given this feature alone. It's also of real importance in the specific context of the changes made, because the evidence demonstrates that it was this new set of changes, the nuancing that's now in the new legislation, was deliberately set up on a precautionary basis. And that in context means tending towards more rather than less disclosure for the time being. And it isn't, of course, only the rights of the applicants for a certificate which are potentially in issue. The whole purpose of the legislative scheme is to ensure that the vulnerable are protected, and in worst cases, that engages rights at the very top of the ECHR hierarchy. So the scales, if you want to view it in terms of balance, are weighty indeed on the other side, we respectfully submit. Secondly, it is a well understood feature of this regime that disclosure can have serious adverse impacts on individuals and their ability to get jobs. But it is a disclosure regime and not a barring regime. W was not prevented from getting on his training course, Statement of Facts and Issues, paragraph 8. P has not been prevented from gaining at least voluntary placements working with children, Statements of Facts and Issues, paragraph 18. And I know my learned friend is going to make some submissions in this respect in relation to the Gallagher case. It is possible to have discussions with the prospective employer. These are carefully selected cases, no doubt, but they are precisely, it might be thought, cases where that discussion can and should occur and is more likely to occur. The scheme does not guarantee it, but there are a range of measures that have been taken to at least try to engage the employers in that discussion. But the essential structural point is that this isn't barring. This simply gives information to the employers. And as I say, the closer one moves to the more difficult case where it's said that the connection to the basic objectives served by the legislation is at its lightest, those are precisely the sorts of cases where one could reasonably expect the employer to take a sensible view about that. So if you can truly point to a case where you say that connection is really minimal, then there's no earthly reason to assume that the employer will take a different view or will not be open to consideration.
assumption behind that legislation is that there are things which employers do take into account and can be expected to take into account, but which they shouldn't be allowed to take into account.
My lord, there are. I don't accept that that leads to the lack of necessity for that regime. We have here a set of rules which filter out. So you've got those judgments about what shouldn't go before them at all, but that leaves, as it were, a group where the employer still gets the information and is still making judgments. Is still making judgments in particular about the relevance of the conviction or caution to the role in question, is able to make judgments about the significance of it truly in that case. So it doesn't cut across the Rehabilitation of Offenders Act. It simply says, take the structural rules that the new legislation imposes with what we submit are all their nuances. You will then be left with information still not filtered out going to employers. And the basic submission is that there is a real difference, a real distinction in principle between a barring service, as it were, and a service under which information is disclosed to employers. I don't for a moment discount or downgrade, as it were, the significance of some of the consideration of these issues in the context of whether there was an interference with Article 8 in the earlier case law of the court in cases like L. And there may well be some employers who say, well, that's it, if you've got a conviction, that's the end of it, or a caution, or anything, I'm applying a blanket rule. There isn't anything absolutely to prevent that. But likewise, I submit, it isn't appropriate in a scheme which is a disclosure scheme to say we can ignore or effectively discount entirely the possibility that the perfectly sensible discussions can happen with the employer. There may or may not be policies in place pursuant to the code that we saw in the evidence earlier on. And my submission is that that is a feature of the scheme that should be taken into account. The alternative being that you have to make everything susceptible to the structural rules in the scheme. So you have to stop it going anywhere near them in any circumstances, and that may be an extremely difficult scheme to design without filtering out too much and risking cutting more fundamentally against the objective that the scheme is designed to serve, which is to protect vulnerable individuals.
Is the test that the information must at least be capable in some circumstances
Yes.
of legitimately influencing an employer, and a scheme, therefore, which bars only things that are incapable of influencing a reasonable employer is fine. I mean, is that essentially what
It's essentially that, and you'll bear in mind that what the scheme doesn't do, and this isn't a challenge feature of it, what it doesn't do is, as it were, to differentiate between those types of profession or job and the information in question. It doesn't link those two, so that if you get something which is principally relevant to financial services and you apply for a job safeguarding children, you get the same information. So that level of distinction doesn't run. So you built into the scheme to some extent is the possibility that information which is overwhelmingly likely not to be of importance or potentially even irrelevant to the role in question may be disclosed. It's just a question of how fine you can cut the structural balances. But the basic point I make is that the temptation, and indeed the premise on which some of the argument is advanced against me, is that because of the way in which the court has acknowledged that some employers may, in a tough job market, say, well, if you've got a conviction, that's the end of it, and just shut the door, that the premise on which the argument is being mounted is that you effectively ignore that part of the scheme. And I respectfully submit you shouldn't do that. It's the disclosure scheme which acknowledges, therefore, that some part of that information on the periphery of relevance, or even not of any great significance at all to the employer, may get through. But it's a part of the scheme to allow for that discussion to take place and to allow for judgments to be made at that level. And as I say, the alternative is that you have to design a scheme so that everything is filtered out, not merely on the basis that it is capable to use that language, but that unless you can say it is squarely going to be relevant, you have to filter it out at the earlier stage. And of course, if you do that by reference to structural rules, you're going to be cutting out a great deal more. And that does risk, therefore, it's part of the checks and balances, that does risk creating a more fundamental impact into the basic objective of the regime, because you have to do it on a precautionary basis the other way, if that makes sense. You have to have more actually filtered out, actually prevented from getting to the employer. I mean, it's an aspect of legislative judgment, but I don't want the case, my submission is that the court shouldn't approach the case on the basis that the employer discussion, judgment, taking into account assessment of relevance and all of that, can effectively be discounted.
Does that sound like a convenient moment?
It does, my lady.
I will look forward to hearing from you further at 2 o'clock.